Thank you so much, Sharon.
You're welcome.
Well, it's an opportunity. I don't think a lot of agents focus on these types of listings, and I imagine that there are lead services that would provide you newly opened probate files and access to other properties that are recently changing hands due to somebody's passing. And so knowing the ins and outs of that is a great opportunity for you guys to get in a niche in a competitive market. When we see real estate get complicated, it's when multiple people own the real estate. You guys are very familiar working with couples and figuring out who's making the decision. Well, if you multiply that by a set of siblings and their spouses, that can get really complicated really quickly. And so we're going to go over a couple of the scenarios that are easy and then get into some of the more difficult scenarios. If you could move on to the next slide. So this is, I know it's what you guys are all good at, asking questions, figuring out what's going on. So possession is 9/10 of the law. Of course, you want to find out who has possession of this house. Often when somebody passes, there'll be a loved one, an heir, a paramour, somebody that's still living in the house. And you want to know who is it that's in that house and how are they connected. Of course, if it's a tenant, that's problematic, and you want to know that from the outset. These other second and third ones are the things that you normally do. And then a lot of times with inherited property, people are thinking about this as this is my family property, my spouse or my in-laws have nothing to do with it. You guys know that in North Carolina, of course, spouses still have an interest in inherited property, and that often comes as a surprise to both the in-laws and to the heirs. Of course, you're going to express sympathy for the deceased, and you're going to inquire about the reasons for the sale. Some of the other information that you'll want to gather, the obituary is easily available. You can usually find it online, and just by Googling the person's name, obituary, if it's a common name, add NC or add the city, and that's going to tell you who the survivors are. That's an easy way to start figuring out who is it that I can contact, who is it that's likely to have inherited this property. Next slide. So you guys know there's jargon in every industry. There's a lot of jargon around probate and estate filings. This is a lot of the words that we don't use in our everyday speech. Probate, what that means is filing a will. When there's not a will, we still say the estate's being probated, and in that case, there's an application for probate. That's what establishes who owns the property. So if I were to pass, then my wife, without a will, then my wife would go down to the courthouse and she would file an application for probate. On that application, she swears to the heirs, my next of kin. That's what gets filed and probated at the courthouse. Then if it's unchallenged, that becomes the record interest in who owns that property. So if there is an illegitimate child, or if I leave out a sibling and that goes unchallenged for a period of time, that becomes the record interest. So it's really important in this case that you can get a copy of the estate file, or of course ask the attorney to get a copy of the estate file early in the process so that we know who are the record interest holders. Those are the people that own the property. Testamentary means a will. Intestacy just means without a will. Executor or executrix, that's really old language. Executor is the male version. Executrix is the female version. Administrator is someone that's in charge of the estate without a will. So the modern term, what you guys want to say is, hey, who's the personal representative? That sounds like that's the modern contemporary terminology that both administrator and executor. That's a better way of saying it. Heir means next of kin, people that take without a will, and then beneficiary is one who takes under a will. Those terms, you see them used wrong all the time. Beneficiary is a more modern term, but I still hear people using heir most of the time. So a lot of times I imagine when people, they come to you with their letters, they say, I've been to the courthouse, I've got my letters. Those letters have a raised seal, that's their credentials. And so they feel very much in charge when they get those letters. They've done the things, they've been downtown, they've grieved, they've gotten a death certificate, they've had the funeral. They are now going about handling the affairs. There's often this mad rush to do something after somebody passes. These things can be done with more care and time, but people really do feel like they need to do something right away. And so once they get their letters, they're out there, they're doing something. You do want to get a copy of their letters, but the really common mistake is for that person to then assume, well, I can make all the decisions. So it does not mean that they have the power to sell real estate. In North Carolina, when someone passes away, their heirs own the property right away. You've got to think back to common law England, to the medieval ages, when land meant everything, and a lord's heirs were the people that were really important, and you could not take their land away from them. So just because somebody is in charge of the estate doesn't mean that they can make all the decisions for the heirs. But often the heirs want them to, and often the heirs are thinking that they are in charge, and I just want them to handle everything. I don't want to be in charge of it. Quick aside, if anybody ever asks you in a will or otherwise to be in charge of an estate, think long and hard about it. It can be a lightning rod for family conflict. You're under the court supervision, and it can sometimes be a very thankless job. So if you've got somebody who's in that position and you can tell that they've got 3 or 4 siblings and maybe they're all over the country, or maybe they're even out of the country, we don't usually like power of attorney closings, but that's a situation that a power of attorney closing would make a lot of sense. And so you can consider early on at the listing stage saying, hey, why don't you go ahead and get all your siblings and their spouses to sign a power of attorney that says that you can then handle everything. Very often they get right up until closer to the closing and realize that they can't sign for the other folks. Okay, so a couple, I started out with easiest, harder scenarios. So this is the very easiest one. This is the do nothing scenario. This is probably common sense to most of you. Most of you probably know this. But when you have a married couple on a deed and one of the spouses passes, the surviving spouse owns that property right away. That's called tenancy by the entirety. It's the reason why on deeds we put the marital status, one of the reasons, and it makes for a very easy transition. Then that spouse can just go out, list the property, sell it the next day without involving the courts or doing anything. In my experience, people don't lie about this. I've never been told somebody passed when they were still living. But it would be a good idea to get a copy of the death certificate in that course. Of course, there are 2 people that are unmarried, but the deed says joint tenants with rights of survivorship. Then the surviving joint tenant owns the property without doing anything else. So that's the easiest scenario, and you can verify that by getting a copy of the deed. And do you guys know the easiest way to get a deed in Wake County is if you go to the revenue site and then you click on the GIS map, and then there's a little link, an icon down at the bottom. That's a piece of paper with a dog ear. You can can get to the deeds really quick by opening up the GIS map and then clicking that icon with the dog tag, dog-eared page down at the bottom. Okay, so this is really the most common scenario. This is homeowner passed away. The personal representative has gone down to the courthouse. They've gotten their letters. What has to happen for them to be able to sell the real estate? Move back up. This is the best case scenario. Go back to that, sorry, going forward one more time. So this is the estate's closed. And what that means is that the personal representative has done everything. Probably most of the time, if there's a recent passing, the estate won't be closed. It takes at least 4 months, more often a year after passing, sometimes longer. Personal representative went down to the courthouse, they got the estate open, they filed notice in the newspaper, they paid all the creditors, they filed the last tax returns, they did all the things, and now they've got a final approved accounting. That means that now this property is fully administered, the heirs own it, and they can sell the property without involving the estate at all. That would be an A+ for the personal representative if they're coming to you at this point. They have finished closing out the estate. Next slide. Okay, in that case, personal representative no longer has any role. The spouses of the heirs do still have an interest in the property. You could obtain a copy of the will or application for probate, and then the approved final accounting. That's a court document that you'll see down at the bottom. There'll be a place for the clerks to sign saying that they've approved the accounting. That means they're done, it's finished, the heirs own the property. In that case, of course, the money goes directly to the heirs or the beneficiaries. Just because the spouses are signing doesn't mean that they have a monetary interest. The heirs are entitled to that money. All right. This is where it starts to get a little bit tricky. So imagine a homeowner has recently passed away. The estate was open. They went down to the courthouse, they filed it, and they published the notice to creditors, which ran at least once. That's the key. Once the notice to creditors has run once, the title company will insure the transaction. That's somewhat risky for the personal representative to sell at that point. If they are confident that they have enough money in the estate to pay claims, they can go ahead and sell the property at this point. Well, some reasons that they may not be confident. If someone passes away in the hospital, of course, these medical bills come in over a period of time, and those bills have to be dealt with. Those are high priority claims that have to be paid. In this scenario, everybody's got to be on the same page, both with listing, price, timing. This can be a highly emotional period for a lot of people, and so it's really important that you make sure that everybody's all on the same page, and that's another time to go back to thinking about having all the heirs and spouses appoint power of attorney. So this is what needs to happen in order for a property to transact shortly after somebody passes away. The reason the personal representative has to be involved is that he or she has a right to pull that property back into the estate to pay claims if it turns out the deceased owed taxes or owed medical bills or owed other money, that they didn't just have money in a bank account to pay. So that means that the debts of the estate exceed the assets of the estate. The estate's insolvent. So what are we going to do to be able to satisfy those creditors? Of course, we've got to find the money somewhere, and if they own real estate, that's the most obvious place that we can go to find some money to pay off those creditors. The old joke for real estate attorneys is we just turn around and say, well, we have this grand legal opinion, we research these statutes, and then we just have to do whatever the title company tells us to do. So in that scenario, the title company says everyone needs to sign. Everyone is the personal representative, the heirs, and their spouses. And that's who I would get to sign the listing agreement. You guys don't typically have spouses sign the listing agreement, right? Do you? They do. Yeah. They need to know that they're engaged, that they're on the hook from the very beginning. This is what a lot of times people think the case is, but it's fairly rare. So most wills will just say, okay, everything to my spouse, and then if I die before my spouse, and everything to our kids. Some wills will say, I want the real estate to go to the personal representative to be sold, and then I want all that money to then go to my beneficiaries. That's pretty rare. We don't see wills that say that often. Sometimes they say something like that, and we send them to the title company, and we get back a lot of different answers about whether just the personal representative has to sign or whether everyone has to sign. I wouldn't try to interpret that myself. I would get the attorney, and then of course the attorney's going to turn around and just ask the title company, will you insure this with just the personal representative signing? If the will does say that, then the money goes directly to the estate. That's more expensive for the estate. They've got to pay probate fees. They probably don't want that to happen. In the other scenarios, we can just pay the heirs directly their share. That's a better scenario. And to talk for a minute about what that means for them from a tax perspective, you guys are familiar with step up in basis. What that means is that if someone passes away, the real property has a basis that's reset to the fair market value at the time that they pass. And so the takeaway is that if someone then sells real estate shortly after a passing, there's no capital gains tax. There's only a tax on the increase in the value from the time that the person passed until it was sold. And so a lot of times you see property sold very recently after somebody passes because the deceased didn't want to incur that large capital gains tax liability. All right, these are the hard scenarios. If there is a dispute about the legitimacy of heirs, this is high family drama, this is soap opera stuff, we need to have our hard hats on if we're going to get involved in a scenario that involves legitimating heirs to a property. So in that scenario that I talked about where there is debts that exceeds the asset in the estate, the personal representative can file what's essentially a lawsuit to bring the property back into the estate. That involves a judicial sale and upset bidding. That's where you need to be sure to disclose to the buyers that, hey, just because you're making an offer and you have an accepted offer on this property doesn't mean that you're ultimately going to be the buyer, because it's going to go for upset bidding down at the courthouse just like foreclosures do. That's a pretty rare scenario. If you get involved in one of those, I would be sure we've got like a one-page disclosure about judicial sales and upset bidding that we use, because buyers can be upset if they think they've got an accepted contract and then find out somebody else is willing to outbid them. Poor will drafting, some of the older ones, or some poorly drafted ones, will say, my homestead to so-and-so, and then, my beach my rental property to so-and-so, and then it turns out that, they start living at the beach, and there's some question about what the will is describing. That, of course, needs to be treated with care. And this, it's really easy for me to make up my mind if it's just me, sometimes I can waffle, sometimes I cannot agree. But if you've got multiple people involved in a real estate transaction and they don't agree, that can make it really, really complicated. Or estate planning, if one of the heirs is a minor or incompetent, that involves a lot of judicial protection. It's going to be a fairly involved process that involves a lot of time if you know that one of the heirs to the property is a minor. There's a good way to protect against that in estate planning, but without a will or poor estate planning, sometimes a minor or somebody that's been declared incompetent can end up with an interest. Of course, you guys are familiar with our favorite are transcontinental closings. That always is very fun, especially when it was difficult to get into an embassy to get anything notarized over the past year and a half. Those are hard scenarios. And I just had this come up recently, and I wanted to be able to help this person. I really wanted to be able to help this person. And then they told me, yeah, well, there was a will, but I didn't like what it said. And can we just file the application for probate because my ex-spouse should have left everything to this kid, but he didn't. It's a really serious. This is someone's last wishes, and we have to respect what their wishes are, and should be taken very, very seriously. And there can be reasons for that. There are ways to revoke a will that are really common sense. I mean, if you find a will and someone has just written void on it, that voids the will. If they destroyed it, if they've torn it in half and you find it ripped into pieces, that destroys it. But you can imagine these issues are very fact intensive. It's going to come down to, well, then who ripped it? Who wrote void on it? Where was it? Who had control over it? And those are very sensitive issues that have, a lot of dollar signs behind them and emotion. Next slide. Okay, so just to review with what the most common scenarios are. So if there's a closed estate, you need the heirs and their spouses. If there is an open estate with no will, heirs, spouses, and personal representative. Usually the personal representative is one of the heirs, in which case the personal representative's spouse needs to sign. Sometimes it's a CPA or a lawyer or just somebody else that the family trusted to handle the estate for them. And in that case, you don't need the personal representative's spouse to sign. They've got to do the things, which are, the big question is, did you go down to the courthouse? Did you go to the 12th floor of the Wake County courthouse? If they did that, then they should have their letters. And then the next question is, well, did you file that notice in the newspaper? If they've done those things, then they can sell the property. You ought to stop them and say, well, you definitely want to talk to a lawyer at this point, because what they'll do at the courthouse is they'll get them in there, they'll file the will, they'll get them their letters, and they're off and running. And then for a whole year, they're doing stuff. And when they come back in a year, they'll say, well, have you done this, this, and this? It's very easy for them to get to the courthouse and to get off and running, and then not realize that they're not accounting for the money properly, and that there were claims they didn't know about that were just in the courthouse file and they get tripped up. And you may have already helped them with the sale of the property and they were so happy about that, but they don't realize a year later that they put themselves in a little bit of hot water with what they're doing at the courthouse. So it's a good time to stop and remind them, hey, be sure that you talk to an attorney or somebody that's familiar with the state administration before you just run off and sell this property. Open estate with the will, beneficiary, spouses, personal representative, and those 3 points still apply. The notice to creditors, which is really easy to do. Most people use the internet. There are other newspapers in Wake County that they can use, and they'll walk your people through it if they have questions about how to run a notice to creditors. If the will directs the sale, which is what a lot of people will go into thinking, then it's just the personal representative, and that can be a good scenario for you because then you're just dealing with one person. And then these are the special scenarios: minors, incompetence, state of death, legitimacy, secreted will. And so that's it in a nutshell. I know there are some questions you guys told me that you had that you wanted to surprise me with at the end. Maybe I covered something close to it, or maybe not.
It's not related. Before you came in, we were talking about filling out the listing paperwork, and there's a section on page 1 where we are supposed to represent what Wake County tax data has on any given property. I have been putting the PIN number and the capital letter description, and I have been closing transactions like that for 8 years. One of my counterparts in this room, who I will not identify, feels that I have not filled out the blocks completely. We would like to get an answer to that.
Okay, and so is the question whether that is a complete,
is that enough for you
accurate
to complete the transaction? Is that enough information for you? The PIN number and the legal description in capital letters that says PH phase, whatever, lot, LO, whatever, neighborhood, subdivision, whatever the title is that sufficient, or do you need all of that?
And so you're taking that from the property tax card up there at
I
the top.
literally select it, copy it, and paste it. Select, copy, paste, and I move on. Okay, I think I know what your answer is. All right, she's right.
No, I can identify the property with that. I mean, there's a PIN number that relates to a property card, and that's what you're selling.
Mm-hmm.
That identifies the properties. Mm-hmm. You know, on the deed, we try to identify the property in multiple ways, mm-hmm. right? And there's the real estate ID number, which is what the revenue department uses to match up the property tax card with the tax bill. That's the 6-digit one. REID number. And
that's not the PIN number,
that's not the PIN. Then
okay.
the PIN number is what GIS uses to zero in on a map on what the property is. And so in a lot of other states, I guess they only have one, because the lenders are always asking us, wow, which one are you using? But that's the difference between them. The real estate ID is for the revenue department, the PIN is for the GIS department. They both identify the property, and then the brief description that appears at the top is usually right. It's not always right. And so, I think that's where this person is saying is that it would be better to pull up the deed and put the full legal description there. In Somerset subdivision, it's lot 44. It's easy. Everybody knows it.
And I guess my confusion is, rather than put BS in there, what they're asking for on the listing page does not match up easily with what's on Wake County tax data. So rather than me put crap in blanks that doesn't really match, I just put the things that I know are correct, and I've never had anybody say, I've never had a closing attorney say
Let me just jump in real quick, because this is not about identifying the property for the closing attorney. This is about contract law, and it's identifying the property between the buyer and the seller. So you want to make sure you have the most complete, accurate information Again, sometimes addresses change in new construction, it's not the same. So I think the point was, and then when you're pulling off of the summary description on there, that can be wrong. So if you're putting two things wrong, which one's right, what controls, there's a hierarchy of what controls from deeds to contracts. So whichever one is the most accurate deed page, referring to prior deeds, those kind of things. Those are the kind of things you're doing, not to identify for the attorney. The attorney can find it no matter what. It's more or less, if it went to court because there was a mistake, the blanks need to be filled in so all parties know what they're selling.
But I'm saying it's not clear.
We'll have some training on that because I think it is pretty clear. Wake County particularly is like one of the best websites ever for real estate.
Well, I mean, even Meredith said it wasn't clear a few minutes ago. So,
Yeah, it's not whether it's clear or it's not clear, you just don't know where to go for information, so we'll teach you where that is.
all right.
Okay?
So we try to put as much information into the deeds as we can so that we can identify.
Like there's a bookmark on the page, there's a deed, all those, there's a place for everything in that contract.
Did you guys know all this stuff? Most of
I knew
it?
some of it
How do
because
you
I lived
know?
through it, but not all of it.
How do you know if you're an executor over an estate? I mean, what if this person that dies never tells anybody who's in charge of what, and you find out after they're dead?
So when you do
And you
your
have 4 siblings.
estate planning, you should go and say, Meredith, this is my chance to tell you, you're my executrix, if you accept that position. You should go to the person that you choose and say, hey, this is where my important papers are. I've asked for you to be my personal representative. And then I've written you a letter that says, here are some of the most important things to me, including what I'd like to happen in the event of my passing, who the people that I trust are, who my CPA is, who my lawyer is, where my life insurance is, all of those things. And then that's the proper way to do it. Now, if somebody dies without a will, it's next of kin.
What if you, next of kin is 4 exact siblings?
Then you each have a right, the first right, you're two relations away in the case of siblings, you each have a right to administer the estate. And the court will have a hearing, if all 4 of you
Okay.
want to do it, the court will have a hearing and choose who they think is best suited.
So our parents have chosen me and my brother, right?
As co-executors?
Yes.
Okay,
How
and
do
I
we
didn't
know
think
that?
about that.
How the hell does that work?
It's not an either or, it's an and. So everything has to be done by consensus, it's unanimous. You and your brother have to agree.
Must be what they
Because
chose.
definitely in-laws don't get the middle of it.
Just to kind of quick wrap up, kind of the whole reason, what kind of helped get you here to talk about this today is we did have a listing that was in an estate without an attorney assistance. So, and when we got close to closing, we realized there were some holes. So the big point was showing all the parties that are need to be involved from the listing contract point going forward, particularly if you find out there's not an attorney handling the estate for them, you've got to start asking a whole lot more questions sooner, because this was almost in a situation where the seller would be in a breach of contract, have to give the buyer all their money back and all their inspections and everything, because they couldn't close within the 14 days because they hadn't done the advertising. And the title company wasn't going to step, so all those steps and those pieces parts, particularly if there's not an attorney involved, kind of protect your client because you're going to set them up for failure. If they think they have a power of sale clause and they don't, or a directed power, so it was touch and go, but it did work out. But these are the kind of questions to ask before the listing is even taken. And making sure all those parties that are involved sign the listing agreement will make sure they're not going to be a problem signing the deed or a contract. Because you'll know right from the beginning if there's a problem with the heirs or beneficiaries signing the listing agreement, then there really is going to be a problem when you sign a contract or a deed.
The form fields and zip forms, Does the font just keep getting smaller and smaller? Somebody recently told me that, like, there was multiple people, and I know there's an additional signature.
I think you have to do
sell it.
Yeah, I think you have to. It depends where I probably have to create a document for something.
So what if there's, after they die, there's so much money owed, there's not enough to sell to cover it?
Yeah, we can still sell the real estate. Good news.
Who's left holding the bag?
So what happens in that case, so imagine that $1 million house, but there's also $2 million in taxes. The personal representative can bring the real estate back into the estate to sell it. The real estate commission gets paid, and then all the money left over goes back into the estate, and it gets paid out pro rata based on who's owed. There's a hierarchy. In that case, I just said, the IRS is going to get paid and there's no money. If there's a bunch of regular, normal credit card creditors, we just take the money and pay it out pro rata to the creditors. Nobody's ever personally responsible for their loved ones' debts unless they were also on the credit cards.
So I have another question for you. I've had clients out of state trying to sell a piece of property here. There's no house involved, there's nobody living there. Several heirs spread across the country. They're all in consensus they want to sell. They have a copy of the will and everything else, but it's been probated out of state. Do they also have to probate it here?
Probably not. In that case, what we would do is to get a certified copy of the estate file from whatever state it was administered in. And so that's where they said, hey, let us know if this person owed money. And they administer all those claims, and then you take that whole estate file, then you file it in Wake County, or whatever county the property's in, so the title searcher can follow the chain of title and say, okay, this person owns the property now, the estate's been fully administered, we don't have to do anything here in terms of running notice to creditors, we can just file that fully administered estate in the county where the real estate is.
Okay.
There are a lot of these small estates, affidavit by collection, where if somebody passes away and there's just a surviving spouse and there's a car, there are these shortcut estate, and be sure that they haven't done that. When there's real estate involved, the clerk's office should be telling them, you need a full-blown administration with notice to creditors. But sometimes if there's a surviving spouse with a car and they don't think about the real estate, they do these shortcut administrations, which are great, except that there's real estate, it's not good enough to then later sell the real estate.
Wait, what?
So,
Because I had that happen.
uh-huh.
So I sold his car and his trailer. And then about 4 years later, I sold the house.
So 2 years is a magic number.
Okay, 2 years, gotcha, okay. I thought you were just grabbing a number out of the air. Okay.
So 2 years is the statute of limitations on claims against an estate.
Okay.
So that notice in the paper is meant to say, let me know what we owe.
We did that.
And in your case, you filed something that established the record interest holders who owned it. And then you didn't have to do a full estate administration because the statute of limitations passed before you went to sell the real estate. Don't count on that. There's very specific scenarios, but that 2 years after somebody passes, creditors can't come back. They've got to be barred at some point. 2 years is the magic.
Okay, 2 years, got it.
So another scenario for you. I have to walk away from a listing because the gentleman called me from Florida. I have my grandfather's land. How do I sell it? And I called the county, it's in Chatham, it's not Wake County where it's nice and clean. No. And when I talked to the clerk there, they said there's 36 heirs listed. Here's the list that I know of. and it was maybe 17 or 18 people, most of which, many of them have passed already, leaving it to God only knows who else. How does anybody, who begins to do that investigation if, like, a gentleman who wanted to sell it has no idea who was legal on?
I would handle that with a partition proceeding. And so that's when multiple people own real estate. One of them can go to the courthouse and say, we just don't agree, I'd like to have this property sold. And the court will appoint a commissioner to sell the real estate and then research who's entitled. But then you're dealing with just the one commissioner. It can be, the commissioner gets to choose the real estate agent in that scenario. So you need to be sticky with it from the beginning that, hey, I'm the one driving this, I want to be the agent. But the commissioner in that case would ultimately choose who the real estate agent was.